I bring you some hopeful news regarding our David and Goliath type challenge to have publication bans varied. The publication bans that a BC father recently breached to raise awareness about the medical transitioning of his child without his consent. And they're also the same bans that restrict me from effectively bringing you that full story. An attorney general for the court shares a vital concern we've had with these bans, and I'll update you on how so in a moment. Drea Humphrey here with Rebel News. Now, if you don't know who the father is that I just mentioned, you can find the full reports on his case by searching AB versus CD at rebelnews.com. You see, Canada isn't just gaining international attention for throwing Christian pastors behind bars. It also recently sentenced a BC father to prison after he breached publication bans and orders that restricted him from things like showing his own face, explaining details relative to what he believed played a key role in his child suddenly having rapid onset gender dysphoria, and discussing the doctors who gave the green light to allow his child to take cross-sex hormones linked to sterility and other health issues long before that child's brain would be fully developed for things like reasoning and decision-making. To make matters worse, I too could wind up behind bars if I breached some of those bans when trying to inform the public of his story. And believe it or not, these same bans that restrict me have often been done in secret. Can you believe it took us hiring a top-notch lawyer named Kyle Benvenu to not only put forth the application to try to have some of these bans varied, but just to properly explain the bans themselves to me. He had to find them, he had to untangle them, and then he had to explain them and file the application. That's how risky the Vancouver Supreme Court has made bringing you as much as I possibly could on this story of great public interest. Kyle has done an amazing job putting forth this application, having discussions after discussions with the various people involved in this case and lawyers. And I want to say a special thank you for everyone who's made that possible by donating at letusreport.com. And of course, ask that you continue to do so because this continues to be a costly application. Now, we understand that it's an uphill battle to try to have the courts acknowledge that the public deserves to know more about this case and that some of these bans should be varied. But we do have some hopeful news regarding the Attorney General's response to our application. Our lawyer, Kyle, will give you that quick update. Kyle, thank you so much. Can you touch a little bit about what the Attorney General's stand was on our application?
Yeah, so we've received now the responding material from all the participants in the application. And not unexpectedly, most of the participants have opposed Rebel News' application. That's how this process works, and for various reasons. But what has stood out as being perhaps a bit of a surprise, or at least a happy surprise to Rebel News, is that the Attorney General, without agreeing with Rebel News and without sort of supporting Rebel News, has filed a response which seems to suggest and at least seem to imply that the precise terms of the publication bans which are at issue here should be made public, and that it should be more than just the fact that there are publication bans, which should be broadcasted and which should be made known to the public. And I think it's important to recognize that without Rebel News's application, without bringing this application forward, those specific terms might never have become part of the public domain. It might just simply have been the broader, more general points that the publication bans simply exist.
So am I right to assume that if this was to set path to a new way, it would kind of change the pattern we're seeing of secrecy when it comes to what I, as a reporter or anybody in media, knows that they can officially report on in cases like this?
Well, whether this becomes a change to the law more broadly, or whether this is an exception for this particular case, remains to be seen. But it's certainly an acknowledgement that there are circumstances where there should not be secrecy and there should not be hidden terms of orders, that those terms should be made public, especially where there is media interest, where the public has interest on the story and wants to be involved in this process.
Thank you very much.
You guys, YouTube is trying to get rid of us. They've deplatformed us, and we know we're gonna be taken off any second. You have to go to rebelnews.com. We need your phone number or your email so that we keep in touch.
Most journalists would simply toss their hands up in the air and walk away from reporting on this important case for you, but not us. We've done everything we can to make sure our hands are clean as we go into this battle because we understand how important it is to have freedom of press, even if the courts just think it's some sort of afterthought. Now imagine if our choice to do this challenge results in a new precedent being set that makes it more difficult to deter reporters who are not afraid to bring you the other side of the story about important issues like the lack of parental rights that can follow after your child is trans identified in school. Now, the battle is far from over and more costs are occurring, probably as we speak. So please join us in this challenge by donating what you can by heading to letusreport.com. We appreciate your support. Drea Humphrey for Rebel News. Thanks again for all of you who are heading to letusreport.com. Unfortunately, I get the feeling this might not be the last time I report on such a case that has similar bans, and I would like to make a difference in that area. If you agree with me there, we can do this fight together until the next report.